He said, I have a relative that inherited a city block in a trust who wants to develop, but there are legal roadblocks caused by administrators of the trust and does not have the financial resources to resolve it. Plus, he has some type of impairment, but he may be able to make legal decisions. He is willing to partner with investors that are willing to help navigate through the problem. The property is at, and he gives the address, and it's surrounded by McDonald's, T-Mobile, 7-Eleven, and has been approached by Chick-fil-A and others.
Wow.
What are your thoughts? And Ernest is here so I can let you guys discuss.
Thank you. So Ernest is under liberal comments here with us. Hey, good to see you and good to hear from you, Ernest. The most important step is whoever is disagreeing in the trust, they got to reach agreement. Without agreement, you're going to get Chick-fil-A wanting to sign and nobody will sign. You're going to spin your wheels. So first step is, here are our intention for everybody to make money. Are we all in agreement? Everybody should sign here that this person is going to be in charge and will make every effort to benefit everybody and will be compensated this way or that way. Maybe the best step will be you can step in and say, I'd like the option to buy the property. I'll commit X amount of money. I'll put maybe 10,000 now and I'll start making some efforts to see if I can get financing or whatever. But what you're gonna do is you're gonna talk to Chick-fil-A, you're gonna talk to the other tenants, line them up, and then it's gonna make financial sense. You have already a fund set up with us. Some deal like this that's all pre-cooked and ready to go to the next value. Oh my God, people will come from the woodwork coming in with you because it's gonna be corporate guarantees, it's gonna be big tenants, it's gonna be a beautiful deal, but you gotta get all these people involved to sign in agreement. Simple, one page. You know, if you allow me to do this, I can cash you out. I need, and then ask them for 6 months. They don't know. If they knew any better, they would be actually fighting about who's gonna own it. They're just fighting because egos get in the way and confusion, etc. And everybody tries to outsmart the other person. I've seen it so many times in probates, in inheritance cases, in illnesses. So just be the smart one and step in and say, I'll cash you out, but I need access and I need this, and here's what I offer you. And see what happens. Would that make sense?
Yeah, but he's the only person in the trust. The problem is, this has been an ongoing problem. The problem is about 10 years ago, the administrator liquidated over $1 million in assets in the trust. He had more properties. And they put this block under agreement to sell for like $400,000 or $500,000. And now the buyer is fighting to close the sale.
Yes.
The trust has been turned over to supposedly another relative. And he's been fighting in court to fight the sale based on the value, because now it's like worth about $5 or $6 million easily.
I would say.
But they're running out of money, and they I don't know, they need legal expertise to work out all the whatever entanglements.
Okay, so
it's not a matter of him not wanting to partner with someone. It's a matter of he doesn't know where to get help.
Okay,
and the lawyers we did talk to, who specialize in helping trust, the person that's the beneficiary, work against, settle things with the trustor or whatever, the administrator, didn't see a clear path to how they would get paid for untangling it. So they kind of backed off.
Okay, got it. May I ask you, when the deal was made for that person to buy it at $400,000 or $500,000 at that time, what were the conditions? There has to be conditions. You close by a certain date, you're gonna submit X, Y, and Z, you're gonna put non-refundable deposit. So on these conditions is where you have the leverage. Okay, I've done many deals where people wanted to back out and all this, and we just went back to the clauses where, well, you didn't do this, you didn't do that. You see, so that's what you need to look into. I mean, I'm not an attorney, but I've done enough deals. If you want me to review those things, I can maybe point out a couple things for you, send it to Ashley, I'll review it, and maybe point out a couple things that you can point to an attorney. And if there is that much difference in the value, I know the team, the trustees or the beneficiaries cannot afford an attorney, but if there is that much added value, you can offer an attorney's firm, I'll give you $500,000, get me out of this deal. I want to get it back into my court here, into the trust. And they will jump in on it. It's all about money.
Because originally it was held by a bank. And the bank asked them to sign an agreement saying that he won't come after them. And they made him pay for that by selling one of his properties. And also they also approached the buyer to not come after them. And I think they paid the buyer, which didn't make any sense to me. Why would he have to pay them to not pursue them? You know what I'm saying? You understand what I'm saying?
Good.
They should be compensating him to keep him from coming after them.
Yeah.
But like I said, he has some kind of, you can't tell that he has some kind of mental impairment by talking to him or being around him. And some of it is just not knowing, just what he doesn't know.
That's good. The more confusion, the better. Because the more confusion, it will show that there was never a meeting of the minds for a contract to be executed. Okay. So what you're telling me actually works to your advantage. Like, I know it's 10 years ago or whatever, but it's what you can prove in court. And if you can prove confusion, you prove enough doubt for the judge to say, then you know what? He will have to get this and you will have to get that. In cases like this, in general, again, I'm not an attorney, but I've been to court enough times to tell you that in general, when there is confusion, the judge then will say, this is what I'll give this party and this is what I'll give this party and that's my final decision, take it. And then one of the parties will have to appeal and then it gets even more complicated, and guess what the next judge does? Supports what the previous judge did because he or she does not have time to look into it deeper. We're going to uphold the previous decision. Or we're going to go to the Supreme Court, shove it back to the local court. I am dealing with lawsuits that have lingered for 8 years. They're unfinished cycles of actions, but they don't bother me at all. I actually look forward. I put them on my board. Here is my board right here, right, with all the numbers, and I put on it that I'm gonna win 1 million on this one, 500,000 on this one. I put it as a positive thing that's gonna happen. And whether I get a million or 100,000, it's a positive event. So my point is, look back at the details, talk to an attorney and tell them there is 4.5 million potential upside here. We're willing to get the firm on a contingency basis, at 10% of that upside. That's $450,000 for a law firm. And I can tell you, it will get the interest of many attorneys. Many attorneys.
Thank you very much.
Sure, you're welcome. Happy to really follow up on this. This is like a little riddle, but it's well worth the solution.
Absolutely. Okay.
Happy to help anyway. If you want me to review anything, it's going to be fun.